Manibo. I'm a senior attorney here at Wang Law Office, and you are watching the AM show, Wang Law Office's question and answer YouTube show.
Hi, my name is Ariel. I'm the host. I'm also a senior paralegal at Wang Law Office. Our show going to start every Friday, 11 a.m. EST, 8 a.m. PST.
So this show answers all your common immigration questions, and we encourage everyone to reach out to us if they have anything that they want to know. You can reach out via line or email or YouTube. Now, this week, we are answering questions that are related to death. Sometimes, unfortunately, death happens to everyone, and it could affect your immigration case. So we want to know what happens when someone involved in your application dies. This could cause some problems, and we'll discuss some of those problems today.
Yeah, Victor, before we start today's topic, can you introduce a little bit on your own background?
Sure. Again, my name is Victor Manibo. I've been a lawyer for more than 12 years, and I've been with my law office for more than 10 years. I'm licensed in New York and New Jersey, and I graduated from Cardozo School of Law here in New York City. I specialize in immigration defense, which is defending people from removal by ICE. I also do immigration applications, meaning helping non-citizens obtain legal immigration status. And finally, I do a little bit of immigration, which is criminal law-related immigration, especially when someone who is not a citizen gets in trouble with the law and it jeopardizes their immigration status.
Yeah, back to today's topic. What happens to my green card application if the petitioner dies?
So this is a common question that we get, and the answer is it depends. It depends on what kind of green card you're applying for. Some green cards, like we talked about before with the EB1, they don't even have a petitioner, so that doesn't really affect them. But most green card applications, either family-based or employment-based, they do have a petitioner, either a family member or an employer.
So for the EB case, will there be a petitioner?
So for employment-based green cards, the employer, the company, is the petitioner. And, there is a person who signs all this paperwork for USCIS, right? But it is the company who's petitioning. And a company doesn't really die in the same way that a person dies. So, the death of the petitioner doesn't really affect EB because, like I said, a company doesn't die in the same way that a person does.
So how about a family-based petition or the death of petitioner? Will it affect the case?
For family-based and other types of applications, like asylum, yes, the death of the petitioner matters because we're talking about people petitioning for other people, not companies, right? So when a petitioner dies, it could negatively affect the petition and the future, green card applications that might be based on that petition. And that's what we're here to talk about.
So can you give me an example of the relationship?
Yeah, so we've talked about petitions before, but just to review, for family-based petitions, for example, the petition establishes the familial relationship between the U.S. citizen and the beneficiary, right? The one who's looking for status. And then the green card application is a separate thing that establishes whether or not the non-citizen is eligible to be given a green card. Now, what happens to the family-based petition when the petitioner dies depends on whether we're talking about the beneficiary, the principal beneficiary, or the derivative beneficiary. We've talked about this with family-based petitions before also, but to recap and to give an example, let's say you have a U.S. citizen husband, right, who is petitioning for his wife, a new wife, right? And the wife is a non-citizen. They're the beneficiary. Now, if that wife, for example, has a child from a previous marriage that they want to include in the petition and then get a green card for afterwards, that child is the derivative beneficiary. So let's just remember those terms: the petitioner, the beneficiary or the principal beneficiary, and the derivative beneficiary. Now, we're going to talk about what happens if the petitioner, the U.S. citizen husband, dies, and what happens if it's the wife, the principal beneficiary, dies, because the rules and the effects are different.
So we're going to have two different situations, right? That, of course, we're going to talk more. So let's start with the first one. What happens if I am the beneficiary and the petitioner dies when the petition is just still pending?
In the past, if the petitioner dies, that's the end of it. It's game over. Doesn't matter if it's pending or approved. The case can't move forward. But the law changed in 2009, and now if a petition is pending and the petitioner dies, the petition can still be decided by USCIS, but the beneficiary has to prove two things. One, the beneficiary must be residing in the United States at the time that the petitioner died. And two, the beneficiary continues to reside in the US at the date that USCIS decides the petition. So again, like two things, residing in the US at the time of death and at the time of the decision of the pending petition. If those two things are met, then it doesn't matter if the petitioner died, USCIS can still decide the petition.
So it matters if the beneficiary is in the US or not, right? At the time, whatever happened.
Yes, exactly. That's what they're looking at, is the beneficiary in the US during those two times.
So does this apply to all family-based petition?
Yeah, so these rules, these residency rules, applies to all family-based petitions where the petitioner dies. There are special rules for when the petitioner is a U.S. citizen petitioning for a spouse. Our laws are they treat that very differently. And for U.S. citizen spouses, when the petitioner, the U.S. citizen spouse, dies, there are special rules that give them more options. It's a little bit more complicated. We can talk about that in a separate YouTube, but just know that, yes, it's possible for them and there are special rules for them. But generally, for family-based petitions, these residency rules apply when the petitioner dies.
Yeah, if you hire a lawyer with experience, they should know if that special rule is applied to you or not. If your case is miss some of the situation. So what happens if I am a beneficiary and the petitioner died after the petition is approved, but the green card has not yet filed or just still pending?
Okay, so this is slightly different from the other situation, right? Now the petition is already approved. You've got that approval notice saying, yes, you are related to this person. And then the petitioner dies before you can get a green card. What happens? Does that petition disappear? No. It's still in effect. It's still an approval. As far as USCIS is concerned, you are still related to that petitioner, even though that petitioner is dead. And you can still use that petition to file for a green card. However, you still have to prove those two things similarly. One, that when the petitioner died, you are residing in the US. And two, that when USCIS decides your green card application that is based on the petition, you are still residing in the US.
The residence is so important.
Yes, exactly.
So we just mentioned about the family-based petition, right? I know that how about asylum case? You're going to have a petition or beneficiary. Is the rule going to be different or the same?
The rules are the same for asylum-based petitions. Asylum petitions are kind of similar to family-based because they're through the family relationship, right? And let's say a husband gets asylum through immigration court, and then after he gets asylum, he wants to petition for his spouse. And the wife is going to be the beneficiary in that case, right? And if the asylum status holder dies while the asylum petition is pending, the petition can still survive, can still be decided by USCIS if the wife meets those residency requirements that I keep talking about. It's the same too if the asylum petition is already approved and the wife is about to file for a green card based on derivative asylum. As long as she meets those two residency requirements, in the US when the husband died and in the US when the green card application is decided, then there's no problem. Even though the husband died, the case can proceed.
So back to our prior situation, what happens to my green card application if the principal beneficiary dies and I'm the derivative beneficiary?
All right, so we just talked about what happens when the petitioner dies. Now we're talking about what if the principal beneficiary dies, right? And again, let's start with family-based petitions because that's more familiar to most of our viewers. Let's say we have a U.S. citizen father who's the petitioner petitioning for his adult son. And that son is going to be the beneficiary or the principal beneficiary. If that son is married, his wife is considered the derivative beneficiary. Now, these situations that we're going to talk about now is what happens when the son dies. So the U.S. citizen, the father is still alive, and the wife, is still alive, but it's the son who dies. What happens? Now, if the petition is pending and, the son dies, that doesn't mean the end of the day for the wife. The petition can still move forward and can still be decided. It's still saved by our laws as long as those two residency requirements are met. It doesn't mean that it will be approved for the wife, but it's still possible as long as the wife is in the U.S. when the son died and is, in the U.S. when USCIS gets the petition for the son.
So what about after the petition is approved, but before the green card application is filed or still pending?
Same rule. As long as the wife, who's the derivative beneficiary, meets the residency requirements, then the petition that was approved for the son, even though the son has died, that approved petition remains valid and still can be used by the wife to apply for her green card.
What about other type of derivative, like employment-based?
So I know earlier I said there's not really a petitioner who can die with employment-based, but there are derivative beneficiaries with employment-based visas, right? We talked about this before with the EBs. Sometimes an employer petitions for an employee and that employee wants to bring his wife and kids. And what happens if the employee dies? Well, the wife and kids as derivative beneficiaries can still benefit from the petition. If the petition is pending or if the petition is approved, the wife and kids can still use that, or that the petition can still be decided, or the green card application can still be decided as long as they meet their residency requirements.
So will this apply to other work-related visa?
Not all of them are saved. The only ones that can be saved are employment-based immigrant visas. You can have derivative beneficiaries for non-immigrant visas like L's or H's, but these rules do not apply to them. So for those cases, if the principal beneficiary dies, then the derivatives, the spouse and the kids, the wife and the kids, that's the end of it for them.
How about, is that going to be the same rule going to apply to the asylum derivative beneficiary?
For asylum derivatives, yes. So it's kind of like family-based, if the asylum petition for the principal beneficiary is pending or approved, and the principal beneficiary dies, the derivative beneficiary can still benefit from that pending petition or approved petition.
How about the other visa, like T or U visa?
T or U visas are kind of interesting because those visas, we talked about them before. There's no petitioner really. It's someone applying for status because they were a victim of a crime or alien smuggling. And sometimes they can include their spouses and children in the application, right? And sometimes as the T visa or U visa application is pending, because it takes a while, the applicant dies. Now, the spouse and the kids can still benefit, can still have that application be decided by USCIS as long as they meet the residency requirements. Again, I keep saying this, as long as they're here in the US at the time of the death of the T or U visa applicant, and as long as at the time that USCIS decides the T or U visa, they're still residing in the US.
Yeah, if your principal passed away in somehow, maybe you should consult with a lawyer to see if you still have other options to continue the case. So it looks like the residence is so important in those cases, right? What does the residence mean?
Residence is, a term that's defined in our cases, in our laws. It's the place that is the person's main actual dwelling place, in fact. And it doesn't matter what their intention is. So what does that mean? Their residence is where you really go home to, where you sleep, where you live, where you put your things, where your property is, regardless of what in your mind you think is your real home. So, for example, if you are, temporarily abroad, right? Your home is where you return, where you actually, in fact, go home to. That is your residence. So USCIS is going to look into that. Okay, so what is this person's address? And is that actually in the United States? And is that where they usually, in fact, go home to? It's where they dwell. Dwell is to live. It's where they live. So that's what we're talking about when we're talking about residency.
So traveling still okay?
Traveling is fine. Like, temporarily traveling, let's say, unfortunately, let's say you were abroad and let's say the petitioner dies, and one of the requirements is you have to be residing in the United States when the petitioner dies. If you were abroad temporarily for just like a vacation and you actually do live in the United States, that's where your things are, that's home, you have a return ticket, then your residence is still in the United States. Again, this is like a legal term. It's kind of complicated, but those are the things that you have to think about.
So is there going to have a situation that's going to terminate your residence in the US?
Yeah, if you actually do move outside of the United States, like physically, or if you maintain two residences and it looks like US is just a vacation home, and this is important, if you have a removal order, if you get a removal order legally, your US residence gets terminated. So there are certain situations where USCIS might say, oh, you don't reside in the United States anymore because you're not really, in fact, living here in the United States. Again, this is a legal term. A lawyer would know how to really explain where your residence is.
So do I need to notice USCIS that my petitioner or my principal beneficiary is died?
Yes, it's usually advisable to let USCIS know about this so that you can also show them your proof that you are a US resident and that they shouldn't, just kill the petition or the application. Okay?
So how do I exactly to show USCIS this?
There are a lot of documents that you can use to prove that you're a US resident, but it's the types of documents that like show where you live, your rent documents or mortgage documents, your employment records or your school records if you have them, some bills and letters. As long as you have those documents and they cover the period of when the petitioner or the principal beneficiary died, that should be helpful in convincing USCIS not to terminate the petitioner application.
Yeah, of course, a good lawyer is going to know what to do and then give you an idea what document to prepare from the beginning to end. What if I do not live here during the death or during the petition is decided?
So, sometimes it happens where people after death, they move residences, or maybe they go back to their home country. It might mean that you lose your US residency. It might mean that, in fact, you do not live in the United States anymore. And your petition can't be saved by these rules that we keep talking about. And your application might be denied because your petitioner died and you're not here. But again, and as I keep saying, the term residence is a legal term. Now, your principal actual dwelling place, in fact, is something that a good lawyer will know how to argue, and like where you intend to live kind of factors into that, even though it's not really that important. So if you're unsure whether or not you still have US residency, or like if you're unsure if you living elsewhere outside the US kind of kills your chances with your immigration case, that's something that a good lawyer will know how to deal with.
Yes. So how about the other situation? What does the death of petitioner affect the affidavit of support?
So, with the death of a relative, it's not just your petitions or applications. It also affects other like sub forms, like an affidavit of support, which is submitted with a green card application, and it requires information and the signature of the petitioner, right? If you are a family-based beneficiary applying for a green card, you need an affidavit of support from the petitioner. But if the petitioner dies, that's okay. It's not the end of the world. You just need to find a substitute sponsor. And that substitute sponsor should have status, U.S. citizen or LPR, and should have the necessary income.
So maybe in the other situation, how does the death of the petitioner affect the waiver application?
So this is another thing that is usually submitted with a green card application, right? Let's say someone needs a fraud waiver and they need to submit documentation and proof showing that a qualifying relative is going to suffer hardship. Now, sometimes the petitioner is also the qualifying relative, right? And what happens if the petitioner dies? You also lose your qualifying relative for the waiver, right? Is that the end of it? No. The law that we keep talking about also protects your waivers because it's part of the green card process. So if your waiver has been filed and is pending before the petitioner or the qualifying relative dies, and then if you meet the residency requirements, then if the waiver is pending, it can still be decided by USCIS. And if the waiver is approved, then you can still use that to get a green card.
So death might not stop your immigration path. You might have other way to save your own case, even though the person, maybe your spouse, your petitioner, whoever passed away. If you consult with a lawyer, the lawyer might still find a way to help you, maybe to save your case, save your petition, save your green card.
Right.
So if you have more questions, feel free to leave your question to us with any of our platform.
And again, at the end of every show, I keep saying this, everything that I've talked about here is based on my opinion and based on my experience as a lawyer. It does not constitute legal advice. It's not advice particular to your case or to anybody else's case. And it is not legal representation. It doesn't mean that I represent any of you just by watching this YouTube video. But if you want legal advice, if you want advice specific to your case or maybe your family member's case, or if you want our firm to represent you, please feel free to reach out to us.
And please continue to follow us on YouTube. Thank you. See you next time.
Bye.